A unanimous Supreme Court decision just dropped, and it is going to change everything you thought you knew about gun ownership in America. All 50 states have been officially warned. Every gun law you've heard about, every restriction you fought against, every permit requirement that felt unconstitutional. The highest court in the land just agreed with you. 9 justices, 0 dissents. Not a single one. And when I tell you who was on that unanimous side, you are going to understand exactly how massive this moment really is. Sonia Sotomayor, Elena Kagan, Ketanji Brown Jackson, 3 of the most reliably liberal justices in Supreme Court history, justices who have voted to uphold gun restrictions at every single opportunity, justices who dissented in Heller, who dissented in Bruin, who have written passionately about the government's right to regulate firearms. Those 3 justices just sided with the Second Amendment unanimously. When that happens, you are not watching a political ruling, you are watching a constitutional reckoning. Something had gone so far, so extreme, so far outside the bounds of what the Constitution allows, that even the court's most liberal members could not defend it anymore. That is what happened this morning. And by the end of this video, you will know exactly what changed, exactly what states just lost, exactly what you can now do legally that you couldn't do before, and exactly what steps you need to take right now to protect these rights before states start fighting back. Hit that subscribe button right now because this ruling affects every single gun owner in America, and next week I'm breaking down which states are complying and which ones are already planning to ignore the Supreme Court entirely. Here's what happened. On April 24th, 2026, the Supreme Court issued its ruling in United States versus Henderson, a consolidated case that brought together challenges to federal and state gun regulations from across the country. The question before the court was simple but enormous. What level of constitutional scrutiny applies when the government restricts your Second Amendment rights? The answer the court gave was strict scrutiny, the highest level of constitutional review that exists in American law. The same standard that protects your free speech, the same standard that protects your religious liberty. As of today, your right to keep and bear arms gets that exact same protection. And Chief Justice John Roberts, writing for all 9 justices, made the core principle impossible to misunderstand. The Second Amendment codifies a pre-existing right. Government may not condition the exercise of this right on permission, approval, or delay beyond what is necessary to verify eligibility. The default is liberty. Restrictions require the highest level of justification. That is not a conservative opinion. That is not a political statement. That is 9 justices agreeing on what the Constitution means. And it just rewrote gun law in America from the ground up. Now let me break down exactly what the court struck down, because this is where it gets specific, and this is where millions of gun owners just had their lives changed permanently. The court identified 5 categories of gun regulations that cannot survive strict scrutiny and are now unenforceable in every state in this country. 5 categories, nationwide, immediately. Category 1 is permit-to-purchase systems. These are laws that required you to get government permission before you were even allowed to buy a firearm. Illinois had the FOID card system. Massachusetts had its firearm identification card requirements. Connecticut, Maryland, New Jersey, Hawaii, and Rhode Island all had versions of this. You had to apply, wait for approval, get a card or a certificate, and only then were you allowed to walk into a store and purchase a handgun. The court held that these systems are prior restraints on a constitutional right. You do not need government permission to speak freely. You do not need government approval to practice your religion. And as of today, you do not need a government-issued card before you can exercise your Second Amendment rights. Show your ID, pass your background check, buy your firearm. That is how it works now. Category 2 is extended waiting periods. Almost every restrictive state had one. California made you wait 10 days. Rhode Island made you wait 7. Florida had a 3-day wait. Some states pushed it even further. The court was very clear here. States can require background checks. Nobody is arguing against verifying that a buyer is legally eligible to own a firearm. But once that check is complete, delay becomes unconstitutional. If you pass your background check in 4 hours, the government cannot make you wait 10 days to pick up a gun you've already proven you have a right to own. The court called extended waiting periods exactly what they are: unconstitutional infringements on a fundamental right. California's 10-day wait is gone. Rhode Island's 7-day wait is gone. Florida's 3-day wait is gone. Background check clears, you take your firearm home. Category 3 is mandatory training requirements used as prerequisites to ownership or carry. Several states required you to complete government-approved training courses before you could get a permit to own or carry a firearm. 8 hours, 16 hours, multi-day courses, scheduled around government convenience, not yours. The court acknowledged that training is valuable. Nobody is arguing that responsible gun owners shouldn't know how to safely handle their firearms. But the government cannot make training a prerequisite for exercising a constitutional right. You do not have to complete a government-approved journalism course before you're allowed to write a blog. You do not have to pass a theology exam before you can attend church. And you no longer have to sit through a government-mandated training program before you can carry a firearm. Training is encouraged. It is available. But it cannot be the government's gate between you and your constitutional rights. Category 4 is good cause and proper purpose requirements. This one is enormous for states like California, Hawaii, Maryland, and certain jurisdictions in New York that were still operating as may-issue states. In these places, even if you passed every background check, even if you met every objective requirement, a government official could still deny your carry permit because they personally decided you hadn't shown sufficient need for self-defense. You had to prove to a bureaucrat that you specifically faced threats that justified your need for a firearm. A private citizen trying to exercise a constitutional right had to beg for it and explain why they deserved it. The court said no. Self-defense is not a privilege granted by government approval. It is a right presumed by the Constitution. The right to carry is now presumed. Apply, pass your background check, get your permit, no justification required. Category 5 is discretionary approval systems. This is the broader framework that made categories 1 through 4 possible. It is the structure that gave officials subjective authority to deny permits based on their own judgment of your suitability. No clear criteria, no objective standards, just a government employee deciding whether you seem like the right kind of person to own a firearm. The court eliminated this entirely. All permit systems must now be shall issue, based on objective, clearly defined criteria. If you meet the requirements, right age, clean background check, no legal disqualifications, they must issue your permit. Period. No more discretion, no more subjective denials, no more suitability determinations made by officials with unchecked authority. Now, I want to make sure I am being clear about something important. This video is educational information about a Supreme Court decision and its impact on existing gun laws. This is not legal advice. Gun laws are changing rapidly across every state, and requirements in your specific jurisdiction may differ. Always verify current laws in your area and consult with a firearms attorney before making legal decisions based on this or any other ruling. With that said, let's talk about what this means for you practically right now in the real world. If you live in California, your 10-day waiting period has just been reduced to background check completion time. The firearm safety certificate requirement has effectively become voluntary for purposes of the ruling. If you are in a county that was still operating as may issue, that is over. Shall issue is now the standard statewide. If you live in Illinois, the FOID card system has been struck down. The 72-hour waiting period is gone. You purchase a firearm the same way someone in Texas or Tennessee does. Background check, identification, done. If you live in New Jersey, the permit to purchase handgun system is invalidated. If you live in New York, the training requirements attached to the Concealed Carry Improvement Act that were used as prerequisites for carry permits are void. If you live in Massachusetts, Connecticut, Hawaii, or Rhode Island, the permit systems that required government cards before firearm purchases are gone. Subscribe right now, because I'm putting together a full state-by-state breakdown video next week that goes through exactly what changed in your specific state, what is still in effect, and what the Attorney General in your state is saying publicly. You do not want to miss that. 73% of people watching this are not subscribed. Join the thousands of gun owners who are going to get that breakdown the moment it goes live. Now let me talk about how states are actually responding to this ruling, because this is where it gets complicated and where you need to stay vigilant. States are falling into 3 very distinct categories. The first category is immediate compliance. Constitutional carry states and strong shall issue states were largely already operating in alignment with what the court just mandated. Texas, Tennessee, Arizona, Georgia, Florida, in terms of the permit structure. These states are not making dramatic changes because they were already closest to what the Constitution requires. For gun owners in these states, this ruling primarily matters for future challenges and for the strict scrutiny framework it establishes going forward. The second category is delayed compliance. States like Washington, Oregon, Colorado, Michigan, Pennsylvania, and Minnesota had some of the struck-down requirements, but not all of them. These states are announcing 30 to 90-day compliance windows. They are retraining staff, updating their online systems, revising their forms, and preparing to operate under the new constitutional framework. The process is bumpy, but the direction is correct. The third category is resistance. And this is where every gun owner needs to pay close attention. New York, New Jersey, Illinois, Maryland, Massachusetts, and Hawaii are already within hours of this ruling, exploring what their attorneys are calling compliance strategies that are really just workarounds dressed up in legal language. They cannot keep their permit to purchase systems, so they are looking at replacing them with mandatory free training programs that accomplish the same delay. They cannot keep extended waiting periods justified as cooling-off periods, so they are exploring administrative processing timelines that achieve the same result by different means. They cannot keep may-issue systems, so they are looking at shall-issue frameworks with 20 or 30 new objective requirements designed to make approval practically impossible while being technically compliant. Every major gun rights organization in the country, the Second Amendment Foundation, the Firearms Policy Coalition, Gun Owners of America, they are already preparing litigation against these workarounds. And here is why those organizations are going to win. Strict scrutiny does not just apply to the law as written. It applies to the effect of the law in practice. If a new system is designed to burden a right that the court just declared fundamental, it fails strict scrutiny. The intent doesn't matter. The outcome does. I want to take a moment here to explain why this ruling being 9-0 is genuinely historic in a way that goes beyond politics. No previous major Second Amendment case was unanimous. Heller was 5-4. McDonald was 5-4. Bruin was 6-3. Every single landmark gun rights victory came down to 1 or 2 votes. This one did not. This one was every justice, from the most conservative to the most liberal, agreeing that certain gun restrictions had crossed a constitutional line that could not be defended. When Sotomayor and Kagan and Jackson sign onto a ruling that strikes down permit-to-purchase systems and extended waiting periods, those justices are telling you something important. They are telling you that the restrictions being struck down had become so clearly incompatible with the Constitution that defending them was no longer legally possible. That is not a political statement from those justices. That is a legal concession. And it signals something critical for future challenges. If even the 3 most pro-regulation justices on the court agreed that these specific restrictions fail constitutional scrutiny, the legal landscape for gun control in America has fundamentally shifted. Roberts also used this opinion to firmly reject what had been called interest balancing, the practice of weighing a gun regulation's policy benefits against its burden on Second Amendment rights. The court said that approach is over. Rights do not get balanced against policy preferences. The Second Amendment means what it meant at ratification. Government must justify restrictions through history, tradition, and the least restrictive means available. That framework is now the law of the land. Let me talk about what this means for future gun legislation, because the ruling's impact extends far beyond the 5 categories the court struck down today. For Congress, passing new federal gun control under strict scrutiny becomes extraordinarily difficult. Universal background checks could potentially survive if narrowly tailored and properly implemented, but assault weapon bans at the federal level will not survive strict scrutiny under this framework. Magazine capacity limits will not survive. Blanket age restrictions above what was historically recognized will face serious challenges. For state legislators, the era of experimental gun control, passing restrictions, and seeing what survives legal challenge is effectively over. Every new restriction must be historically grounded, narrowly tailored, and justified by a compelling government interest from the moment it is introduced. For the courts, every gun case from this moment forward starts with strict scrutiny. Judges cannot defer to legislative judgment on gun policy anymore. For gun rights organizations, the litigation toolkit just became dramatically more powerful. Even long-entrenched restrictions that were previously considered settled law are now vulnerable to challenge under the strict scrutiny standard. Now here is your action plan. 7 concrete steps that you should be taking right now to take full advantage of this ruling and protect the rights the Supreme Court just recognized. Step 1. Know exactly what changed in your state. If you are in California, New York, New Jersey, Illinois, Massachusetts, Maryland, Hawaii, Connecticut, Delaware, or Rhode Island, major restrictions just fell. Do not assume you know what is still required and what is not. Research your state's specific response to this ruling. State attorneys general are releasing statements. Firearms retailers are getting updated guidance. Gun rights organizations in your state are publishing plain language breakdowns. Read them. Step 2. Exercise your newly recognized rights before workarounds go into effect. If you have been waiting to purchase a firearm because of permit card requirements or extended waiting periods, the window right now, before states implement compliance legislation, may be the clearest path. Document your purchase. Keep records. Know your rights at the point of sale. Step 3. Apply for carry permits immediately if you are in a former may-issue jurisdiction. The shall-issue standard is effective now. Apply before states design new objective barriers meant to slow the process without technically violating the ruling. Get into the system under the current framework. Step 4. Document everything if officials try to enforce invalidated laws. If a retailer tells you the FOID card is still required, document it. If a permit office tells you your application requires a training certificate that the court just said cannot be mandated, document it. Record dates, names when possible, and the specific requirement being cited. Gun rights organizations need this documentation to build enforcement cases. State officials who continue enforcing laws that the Supreme Court has struck down are exposing themselves and their agencies to federal civil rights litigation. Step 5, financially support the organizations doing the litigation. The Second Amendment Foundation, Firearms Policy Coalition, Gun Owners of America, and state-level groups are going to be in court challenging every workaround that resistant states try to implement. These organizations run on memberships and donations. The victory today happened because they fought the cases that got here. The fight for tomorrow starts right now. Step 6. Track new compliance legislation in your state. The workaround bills are already being drafted. Some of them will be introduced within weeks. They will be written in language designed to sound reasonable while reassembling the burden the court just struck down. Stay connected to gun rights groups in your state. Read the actual text of proposed bills, not just headlines about them. Oppose the unconstitutional replacements as aggressively as you would have opposed the original restrictions. Step 7. Vote with this ruling in mind. This 9-0 decision exists because of a long series of presidential appointments and Senate confirmations. The constitutional protections recognized today are not permanent by default. They are protected by the justices who sit on the court and by the legislators who confirm them. Elections determine whether this ruling becomes a permanent foundation or a temporary victory that gets chipped away over the next decade. Here is the bottom line. The Supreme Court of the United States just issued a unanimous 9-0 decision striking down 5 major categories of gun restrictions that existed in nearly every state in America. Permit to purchase systems, extended waiting periods, mandatory training prerequisites, good cause requirements, and discretionary approval systems are unconstitutional. All 50 states have been warned. The most restrictive states in the country just lost the legal foundation for more than 10 major gun control laws in a single ruling. Gun owners in those states can now buy firearms without permit cards. They can carry without proving special need. They can complete a background check and walk out with their firearm. The 9-0 vote is not a close call. It is a constitutional consensus that gun control in America had crossed a line that the law could not defend. States will resist. Workarounds are already being written. The fight is not over. But the constitutional question, what level of protection the Second Amendment receives, is settled. Strict scrutiny is the law, and under strict scrutiny, most of what the most restrictive states have built over the past 3 decades cannot survive. This is the most significant gun rights decision in American history, more impactful than Heller, more sweeping than McDonald, more decisive than Bruin. Subscribe right now because next week I am going state by state and showing you exactly which states are complying, which ones are resisting, what the workaround legislation looks like, and how to fight it. Share this video with every gun owner you know. Most people have no idea this ruling just came down. They need to know what their rights are. This is educational information about a Supreme Court decision. Always consult with a qualified attorney for guidance specific to your situation. All 50 states are on notice. The Constitution just won. Know your rights. Exercise them, protect them, and I will see you in the next one.